Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Thursday, March 14th, 2024. We are working off of voting list 12. We're going to start off with Senate Bill 452, Shamari.
Senate Bill 452 establishes that any provision in a contract or agreement relating to the use of a recreational facility that purports to limit the recreational facility's liability or release the recreational facility from or indemnify or hold harmless the recreational facility against liability for injury caused by or resulting from the negligence or other wrongful act of the recreational facility or its agents or employees is against public policy and is void and unenforceable. The committee previously adopted Amendment 503527/1, and that amendment exempts a lodging establishment from the definition of recreational facilities subject to the bill. So there are a couple other amendments in your packet. Amendment 563023/1. And that amendment slightly alters the exemption for lodging establishment. If you look on the amendment you have in your packet 563023 on page number 3, it says a lodging establishment is defined in section 15-201 of the business regulation article unless the lodging establishment owns, maintains, or operates a recreational facility that is available for use by the general public. That amendment also makes a slight change or exempts a health club services agreement from the requirements of the bill as defined in 14-12B-01 of the commercial law article for services to be rendered for an adult. Okay. So in order to adopt, we'd have to consider the vote of the other amendment.
So this amendment, we've worked with kind of all the stakeholders and have come to an agreement for both amendments. So they're both the amendments we talked about last time are incorporated into this amendment. So what we'd have to do is there'd be a motion to strip the prior amendment, which was 503527/1. So the motion would be to strip that amendment and then add this amendment that Shamari just read across. So okay, I'll make a motion to remove the prior amendment. So okay, second. Everyone's good. Okay. Now the motion to adopt amendment 563023/1. Second. Okay. Now the bill's before you as amended. Yeah, that's the one that's right before you. Senator West, I noticed there was an amendment from you on this bill, on this in the packet.
So Senator West's amendment would have also exempted health services agreements, but the way it was drafted would have only made exculpatory clauses that were for children. Those would be the kinds of clauses that would be void and unenforceable. So you wouldn't be able to waive negligence that causes injury to children under all circumstances, not just with the health services agreements.
So Senator West, the amendment we just adopted, which is the first amendment, is the consensus amendment, which does health club. Okay, got it. All right, so motions were favorable. Second. All right, is everyone okay being recorded in the affirmative? All right, Senate Bill 452 with amendments passes unanimously.
Senate Bill 470 is an administration bill that renames the Law Enforcement Cadet Apprenticeship Program in the Maryland Department of Labor to be the Public Safety Apprenticeship Program and expands the purpose and scope of the program, including expanding eligibility for the program to include public safety agencies instead of only law enforcement agencies, which is the case now. The bill also increases the maximum grant amount for eligible apprentices to $5,000. That's up from either $1,000 or $2,000. Additionally, the Maryland Police Training and Standards Commission must develop mental health wellness policies to be implemented in law enforcement agencies in the state and submit a related annual report. Lastly, the bill establishes the work group on growing engagement in the law enforcement workforce, which is to be staffed by MPTSC. That work group is responsible for identifying and studying the shortage of employees in the law enforcement fields, determining ways to advertise and promote law enforcement employment opportunities across the state, and also making recommendations on incentives or other methods to increase the number of employees in the law enforcement workforce. There is one amendment in your voting packet. That is amendment, this is for Senate Bill 470. That is amendment 743-122/1. That's 743-122/1. And it's the chair on behalf of the administration.
Miles a nomination.
Yes, thank you for having me again. Miles Hicks, serve as Deputy Legislative Officer to Governor Moore. Again, I just want to highlight that the purpose of this bill that was mentioned has not changed since the hearing. We just made some more technical changes in hopes that will help better implement the apprenticeship program. So you'll see that there's been a change to establish that you can have a startup grant as well as a stabilization grant. The startup grants are for public safety agencies that are establishing programs, and that can be awarded up to $200,000. And stabilization grants can be utilized for $5,000 per apprentice in these fields as well. That's going to be the biggest change that you're going to see in the first portion of the bill. Later on in the bill, you'll also see that for the work group on workforce development, you will see that the Senate President and also the Speaker of the House have representation added to the board. You'll also see that we also added the correctional facilities as well to that field. That's a recommendation from MACO, knowing that we're not just experiencing shortages in law enforcement, but also in correctional facilities as well. And finally, one last thing we added to that was as well looking at other states and national best practices. So everything, again, the intent of the bill has not changed. What we did to make some technical changes in hopes to make the best work product.
I appreciate a lot. I know a lot of significant work has gone into the amendments with Senator Rosapep, members of Labor. So I appreciate the work that's gone in. I'd like to move the amendments. Second. All right. Now the bill is before you as amended. Further discussion. Motion for favorable. It's been seconded. All right. Is everyone okay being recorded in the affirmative? All right. Senate Bill 470. Excellent. All right. We're going to sponsor amendment to Senator Folden would like to be added in. Senator, I'll go on. Senator James. Senator West, you're already on. Yeah, I'll be on.
James is already on.
She's already on. Yeah, she is. I see her. Okay. All right, Senate Bill 470 with amendments passes unanimously. All right, we're now going to Senate Bill 118.
Senate Bill 118 authorizes a person to file a petition for expungement if the person received a probation before judgment for driving while under the influence or driving while impaired. The petition would need to be filed at least 10 years after the date the petitioner was discharged from probation. The bill also authorizes these individuals to petition to shield a police or court record for these dispositions 5 years after the person was discharged from probation for the offense. The committee had previously adopted amendments on this bill. Those amendments are in your voting packet in a consolidated amendment. This is for Senate Bill 118. The amendment number is 193-024/1, 193-024/1. And this reflects the amendments that JPR had adopted, which includes adding an interlock requirement for DUI, DWI PBJs. It makes expungement eligible at 15 years instead of 10. It excludes drug or CDS and subsequent offenders from being able to petition for expungement under the bill. And it alters the ineligibility requirements of the bill's 15-year expungement provisions and also makes technical changes. Additionally, there was a amendment adopted to move the effective date from October to July. And actually, lastly, the amendment removed the bill's shielding provisions. So this would exclusively be expungement.
Removes the shielding?
Right. So it's expungement, but not.
Remember, we had a shielding as like a step up.
It was
to do shielding.
right. It was the shielding in I guess a prior iteration of the bill was you weren't quite yet eligible for expungement, but there would have been eligibility for shielding. That language had been, I believe, taken out by the House when they sent the bill back to us last year. So the committee had effectively gone with the language that was coming back over to us last year.
Can I speak to the amendment then?
Sure.
So the information I have is that people who abuse alcohol and then drive are likely to do it again. If you've done it once, you're more likely than someone who has not done it to do it another time. We have a real problem on our roads with people who are driving under the influence. I just got some statistics. We're in the Baltimore Sun this morning. I had them somewhere around here that a lot of people have died on the highways in the past year because of people driving under the influence. So my feeling is that if I were a judge and someone came before me with a DUI, I would want to know whether or not that person had ever been driving previously under the influence of alcohol. So that means I'm happy to have a shielding in these cases. I'm not wild about having an expungement, because if there's an expungement and I were a judge, I would not know that the person in front of me has previously been convicted of driving under the influence. So shielding prevents the rest of society from knowing that it occurred, which is fine. It would help that person make his or her way in life without that hanging over his head or her head publicly. But if I were a judge, I would certainly want to know that the person in front of me who's guilty of driving under the influence had previously been found guilty of driving under the influence. It would affect what kind of penalty I would assign and whether I would grant a new probation before judgment as opposed to jail term.
Thank you very much. I understand what my colleague is saying, and he's correct in some respects. I did look into it. Generally, people who are repeat offenders, they do so over and over again. They just get caught every now and then. Somebody who's been out on probation for 10 years, who've not done that in 10 years, the likelihood goes way down. This is according to studies that I've looked at, because I was kind of vacillating with it as well. So I would support the amendment as is.
I mean, to Senator Muse's point and Senator West, it's a policy call. I mean, we bumped it back to 15 years.
Right,
Right.
So
it's not like.
that's the policy call, whether you think that, you know, if someone is not reoffended in 15 years, then maybe they can apply for this to happen. It's not automatic, obviously, but
Okay, well,
yep.
Those amendments have already been adopted.
no, I know, we're
Okay,
discussing. Yeah,
okay,
yeah.
Did we already know?
Yeah.
We already adopted.
Mhm.
What you have is the consolidated amendment of all.
There's everything that the committee's already adopted on a prior voting session.
We've already put the bill together, so it's ready to move as soon as we're ready to finish debating. We did adopt the amendments. Did you?
They were.
Correct me if I'm wrong here, but when we did the amendments, we took away the 5-year shielding. So it actually made it to where it was going to be exposed for everybody to know out to 15 years. At 15 years with no prior or no additional offenses, that the PBJ that they got could be expunged. If they got a conviction that resulted in not a PBJ, it stays. So the amendments actually took away, I think, one of the bigger concerns, which was the shielding at 5. We removed that, make it to where now you can only have it removed after 15 years for a PBJ. So I would just offer that as, I wanted to make sure I had it correctly and as offered as clarification.
Vice Chair Waldstreicher.
Yes, with thanks to Senator Muse.
Senator Sidnor.
Yes.
Senator West.
No.
Senator Muse.
Yes, Senator Wallstreiter, yes.
Senator Folded.
Yes.
Senator James.
Yes.
Senator Charles.
Yes.
Senator Kelly.
Yes.
Senator McKay.
Yes.
Senator Carter.
Yes.
Chairman Smith.
Yes. Senate Bill 111 passes 10-1. Senate Bill 118 rather passes with amendment 10-1. All right, we're now going to go on to Shamari with Senate Bill 57.
Senate Bill 57 establishes that it is lawful for a person to intercept a wire, oral, or electronic communication if the person is working as a fair housing tester for a fair housing testing program operated by the federal government, the state, a local government, or a nonprofit civil rights organization. The person is a party to the communication. And 3, the interception is being made for the purpose of obtaining evidence of a fair housing violation under federal, state, or local law. There's an amendment in your packet. The amendment number is 223-225. And that amendment limits the exception to oral communications and provides that evidence obtained through a fair housing test is not admissible in any unrelated criminal proceeding for any purpose.
No, we had a very good discussion just to address some of Senator West's concerns regarding the use of the terminology wire and electronic communication. So we made some amendments, and I would ask that we move the amendment as well as the bill.
Speaks.
Do we have that amendment?
We do.
Okay, I just have one more question.
Sure, absolutely.
I just want to make sure I'm clear. So on this wiretapping, fair housing testing, this bill as written would require no complaint to be brought forward. Is that correct? So they could just do this
That's what they do.
without complaint?
It's two things that fair housing testers do. They will go out on complaint, and they also go out to keep people, to keep organizations or the folk honest. So that's exactly what it does.
So we're allowing people
To put on a
put on a wire,
to put a tape recorder on in their pocket.
tape recorder or wire, I mean, or whatever, I mean, a recording device,
Correct.
and go in and for no complaint whatsoever and without any allegation of any impropriety, have a recorded conversation in violation of Maryland's two-party consent.
Won't be a violation if we pass this law.
But it goes against everything that Maryland talks about with a two-party consent. Now, if there's a complaint, that's different. But if we're allowing something to just be because we want to have the authority to go and I have a hard time. I don't think this is appropriate without a proper complaint or a complainant. I think this is putting us into a slippery slope, especially when it comes to two-party consent in Maryland without a complaint or violation of a crime or a violation of any
Again,
civil rights issues.
Well, that is the issue. It may be civil rights issues and you don't know. As I mentioned during the testimony, when I used to do this, we had fair housing testers that would go in, they were treated very kindly. They were even offered places or rooms that might be available to rent. They would leave. Then what would happen, you'd have a team of people who would look at all of the tests that happened. And lo and behold, sometimes folk were maybe showing me 1 or 2 rooms, but they were showing the white tester maybe 5 or 6 rooms. So I would not have known that I was being discriminated against. So you take these things, you put all of the information together, somebody sits and looks at that information to decide whether or not to move forward with cases. So this is just another tool to ensure that fair housing laws are adequately enforced.
Yeah. Okay.
Thank you. If someone went in and they taped the conversation and they didn't find any just cause, would that be revealed to anyone?
No.
So then they would have to be breaking the law in order for it to move to another level and for someone else to hear or review it. Is that correct?
Well, again, within the legislation, it's limited to fair housing.
Right, correct.
Right. So
And so
it goes nowhere.
So that's it. And we know we have a problem. We know it exists. And I think every tool that we need to ensure justice, they depend on us to move those laws forward to do it. So I just want to speak in support of it.
Thank you.
What happens after you get a recording that you believe is some evidence of an unfair practice? How does it, what happens to it next? Does it get admitted into court? How does it get admitted into court? Particularly if the person being recorded wants to challenge its authenticity or whether it's been doctored or whether it's taken out of context. And I apologize, I just don't know. So
It would be treated as any other piece of evidence that's entered into court.
well, does it get entered into court or does it?
It can be.
It can be challenged.
Right.
Based on any
Any
other
piece of evidence. Yeah.
normal evidentiary.
Yes, ma'am.
I gotcha. And then but just so I can understand,
Mhm.
for anybody else that's going to be recorded in the state, you have to go to a court normally and at least have a show cause. I don't know what the terminology, you have to show cause a belief that you need to wiretap somebody basically because you have a suspicion they might be violating the law, but that would not be the case here. You don't need that suspicion.
That is correct.
Okay. All right. Hmm.
Where do we else in Maryland code do this? Is there another catch-all that we? So I'm just trying to figure, is there precedent for this?
This, I think there's a list of, I don't know if it's 12 or 13 exceptions, so this will be one of the other exceptions.
Okay. It would be nice to know what those exceptions are.
Law enforcement, if I'm not mistaken.
So I'm looking at 10402 of courts and judicial proceedings. And there's 12 exceptions. Or 11, this would be the 12th exception in law. Or 13th, there's 12. And the first one has to do with law enforcement investigating, certain enumerated offenses. The second has to do with it's in the course of an officer's regular duties. Employee agent of a governmental emergency communication center to intercept a wire or oral communication where the officer is a party to a conversation concerning an emergency. Law enforcement personnel to utilize body wires to intercept oral communications in the course of a criminal investigation if there is reasonable cause to believe that a law enforcement officer's safety may be in jeopardy. And so it goes on like that with similar exceptions.
So they're all criminal violations.
I think they all are, criminal.
And that would be in the same vein.
So one thing that I tried to make clear during the presentation is fair housing testers are usually acting in their capacity as agents for your local and state governments who have that duty to affirmatively further fair housing. So what they're doing is helping your local and your state governments to enforce fair housing laws. So this particular recording can only really be used in that capacity.
Okay. All right, thank you.
Thank you, Mr. Chair. So I just want to also add, thank you for going down the list, Mario. But I have even a bigger concern now looking back at this, because on the fair housing testing program operated by federal government, state, a local government, but then it has a subsection 4, a nonprofit civil rights organization. There is zero binding for them to comply. There's nothing binding for them to comply with this, and they utilizing we're giving them blanket authority to violate the Maryland's two-party consent law, and they have no attachment to any government entity or responsibility to a nonprofit civil rights organization.
Ones who do this on behalf of your local, your state governments. That's incorrect.
Are they? It doesn't say that. It says
that's what they do. So what happens is they go through a training.
Yeah, I was gonna say, let's explain the process, because
So what tends to happen, you have the federal government who sends federal money down to your state and local governments. State and local governments are responsible for, again, enforcing fair housing. They tend not to have large staff. So what they do is they contract out to nonprofit organizations who go through this particular training that HUD has set forth, and they go and they work on behalf of your local and state governments. That's why you had so many local government, the Human Resources or Human Relations Commissions coming and testifying on behalf of this, because these are your eyes on the ground ensuring that the fair housing laws are done properly. It's the nonprofits doing it on behalf of your state and your local governments.
So it doesn't say that in here, that's the training. I understand you're saying that is the case, but it doesn't say that they have to be a nonprofit that has received the proper training.
Look at the definition of a nonprofit civil rights organization, what it means. at the page, beginning of page 2 of 3. It's a qualified fair housing enforcement organization or a fair housing organization as defined under 24 CFR 125.103, or an organization incorporated under Maryland law as a private tax exempt civil rights organization that has at least 2 years of experience in complaint intake, complaint investigation, and testing for fair housing violations. It's no one willy-nilly doing this. And it's only a handful of organizations that actually do this here in the state. I used to be a part of it. I was Baltimore Neighborhoods Incorporated.
Okay, again, there are very strict parameters and I understand what you're saying, but law enforcement can't even do a wiretap and go outside of like a 40-second window of time, depending on what's given by the court. And if nothing is discussed, they got to shut it down. Like this allows it to go on forever with no time limit of any infraction. You can just record the entire thing. And then that's a lot of problems, and that's really opening up a lot of
outside of Maryland having the 2-party consent. This is something that's done in the majority of states across the country. This isn't anything new.
I appreciate that, but Maryland's still a 2-party consent.
It is.
So I mean that's the reality of it. So thank you.
Thank you. Welcome.
Thank you so much. And thank you, Senator Sidner, for the amendments that you worked on with Senator West. I think they're very clarifying. And for me, what they do is they remind me that this bill is really about fulfilling the promise of our fair housing laws. So my question to you is, some of the things you've shared in your defense of this bill have been really inspiring to me, that you seem to have some personal experience in this space, which I'm interested to learn. This is not a personal question for you, but I think that you can probably really well answer sort of about the promise of those civil rights housing laws and sort of the impact, if we're not fulfilling that promise, what the impact might be on individual families and also society.
What happens, and one of the reasons why this bill is so important, is when you're trying to take these cases to trial, currently under the current system, as a fair housing tester, you go, you interact with the landlord, then you have to come out, get in your car, and you write down what happened. Written notes are one thing for the listener. That's a whole different story when you're actually able to hear what the transaction was. So that's why it's extremely important when your judge or your jury listens rather than just reads a statement. They're brought right there to kind of understand what transpired.
Further questions from the committee? All right, I have one. Just so look, I mean, look, I commend Senator Sidner. I'm very protective of our 2-party consent statute. Every year we get tons of bills trying to strip it away, and I've always put them in the drawer because I'm very, very protective of the statute, because I think it makes Maryland unique, and I think it provides us with a lot of safeguards that are necessary. So commend him for his tenacity, but also the amendments too. And so with my question with the amendment, because I know you worked with Senator West on this, and it's the last page, just you added that, and you mentioned this, you added it cannot be used only for the purposes of enforcing federal, state, or local fair housing laws, and is not admissible in any unrelated criminal proceeding for any purpose. And the question, so I guess help me understand why not for, Senator Waldstreicher talked about kind of the 3 prongs of enforcement: administrative, civil, criminal. I thought that was really, really good. But so why not use, why are we only saying in criminal and not administrative proceedings or not any other civil proceedings? And if they're not civil proceedings or administrative proceedings, do you think this language narrows it down to the underlying act, like to just this, the fair housing violation or the alleged violation, or can it be used in any other civil or administrative hearing or proceeding at this moment under this amendment?
I've read it narrowly, but I will tell you that particular language was offered and accepted by the Office of Public Defender, so they were probably looking at it just from that criminal process.
Because I know we want to use this for a very, very narrow purpose.
If you wanted to narrow it and say anything outside of
Yeah.
I'm fine with that.
Okay, would that, Shamar, would that hurt? I mean, I just want to make sure, I'm like, very, very protective of this, so for the, but I'm also very sensitive to the needs here. Shamar, is it possible to do this in line, just say, just for, I don't know how you want to say, how you attenuate it, but just for the very narrow purpose of an administrative or civil proceeding, attached to the underlying alleged violation of fair housing laws, whatever.
If we want to limit it, we could strike the word criminal and just be unrelated proceeding for any purpose. And then that would, I think, cover any proceeding that is not federal, state, or local for the enforcement of federal, state, or local fair housing laws.
Do that in line for now. I mean, let's just do that to this amendment, then let's adopt this amendment. Is the amendment before us? Is everyone okay with that? All right, now the bill's before you as amended.
So we did strike that word?
Yes,
Okay.
just further discussion, making sure that belt and suspenders, that's good, right? Okay.
I don't want to slow this down. This is an important bill. And I like the concept that we're talking about here. I just don't understand the distinction that you referenced earlier. Tell me what I'm missing. It's on page 2 of 3. You were talking about the 2 different civil rights organizations. And it sounds like the first one has some kind of training and certification attached to it and is defined under federal law. And I guess federal law allows this because they're they do a lot of fair housing. I'm not sure I quite understand why there's this second group that seems to may not be as well defined or have some of the training stuff that we talked about. Because I'm comfortable with organizations that are like licensed, trained, that kind of approaches more like law enforcement stuff. This second one just giving me a little heartburn.
I'm trying to think back. I believe at the time, and I wish I had Marceline White here because I know there are at least 2 organizations in here. I mean, I think that operate in the state of Maryland. Her organization, and there's one that operates out of the District of Columbia. So I believe this second portion of it was to ensure organizations that had been operating and were not just fly-by-night type of organization. So that it was kind of, I think, something prophylactic. Again, I suspect that, I mean, if you had heartburn about that, I don't think that would harm the bill in removing it. But again, this was just language that talked about an organization that has done this stuff. Now, I mean, that may not totally respond to your question.
So you said the one organization that housing consumer, it's like a consumer protection housing agency, but listed in the fiscal note talks about the Maryland Commission on Civil Rights. So would this apply to any and all civil rights agencies that are that are certified to investigate housing discrimination across Maryland? It would be like this. It would be like the Maryland Commission on Civil Rights. Just about every jurisdiction has a civil rights agency, like the Howard County Commission, the Baltimore City Equity and Civil Rights. It would apply to each of those, correct?
Right.
Those that are already trained and certified to investigate housing discrimination.
Right.
It would not apply to any other entity, organization, or person, correct?
Correct.
So it's not this broad thing where somebody can just kind of explore. I want to see if these people are discriminating and just go do it. It's got to be
You got it. I mean,
a recognized discrimination.
the way, and I mean, but just keeping it real, like the way of describing it, like, is that obviously you get certified, but the nonprofit organizations then go through and get the training. And then is it like the trainer type thing? And then they can go off and train people to come in.
But they still act under the auspices of that organization.
So it's not just MCC, like from Montgomery, it's not just the Anne
Right,
Arundel
so-
Commission,
so
it's also the
you
other
all-
nonprofits, yeah.
I guess it's the Maryland County Department of Health and Human Services came in and testified. They'll hire or contract out, right? Correct.
Can I just add something? So there's already existing admissibility provisions in that subtitle. So my recommendation, based on the amendment we adopted, is that we just adopt the wording that's used elsewhere in the subtitle for an admissibility of evidence. Yeah. And so no parts of the contents of the communication and no evidence derived therefrom may be received in evidence in any trial, hearing, or other proceeding in or before any court, grand jury, department, officer, agency, regulatory body, legislative committee, or other authority of the state or political subdivision thereof, except for the purpose of enforcing federal, state, or local fair housing laws.
Just that one strike. Okay, excellent. Okay. All right, further discussion. Senator McKay.
Mr. Chairman. I'm still wrestling on these 12 others that are in 10-40. So it seemed like the ones that were being listed were all criminal violations, and now we're going to add a civil violation. I mean, isn't that
Characterize the rest of those as criminal, then
But
this is certainly only civil, so.
you know, that's what I'm saying. I mean, so wouldn't that be a different section in the code anyhow? If they were all criminal and now it's civil?
It under the section because this is where the prohibition lay.
Okay.
And again, it's the prohibition and all of the different exclusions that we, or exemptions that we created just happened to fall there. And most of the exclusions or just happened to be
criminal.
Right. I mean, I think the latest large one that we did was back in 2015 with the body cameras on law enforcement officers. So.
And look, we all know I'm not an attorney, but this doesn't violate probable cause or anything like that.
Say it again.
Probable cause.
This is civil, so you don't have that's almost civil.
Yeah, but doesn't the whole probable cause goes down of?
It's about criminal.
Right, but it just seems to me we're kind of like fishing. I mean, and I know that there's training. I understand there's standards. But
if you were to go on the Maryland United States Attorney's website here in Maryland, they do this stuff for federal violations. They do it in consumer auto kind of cases. This is strictly limited to housing. The sole reason we're in this, even asking for this type of legislation, is because of the states, and again, state law states two-party consent language. So I mean, I don't know what else to say.
Understood.
Yeah.
Thank you, sir.
No problem. Please, I again move the amended bill.
Vice Chair Waldstraker,
Yes.
Senator Sidnor,
Yes.
Senator West,
Yes.
Senator Muse,
Yes.
Senator Folden,
No.
Senator James,
Yes.
Senator Charles,
Yes.
Senator Kelly,
Oh, yes.
Senator McKay,
No,
Senator Carter,
Yes.
Chairman Smith.
Yes. All right, Senate Bill 57 with amendments passes 9-2. All right, we're now going to go on to Shamari. We're going to stick with you for a little bit. Senate Bill 708. It's a departmental bill.
Senate Bill 708 generally alters statutory provisions relating to the kinship care program within the Department of Human Services to further prioritize placing children in need of out-of-home placement with kinship caregivers. Notably, among other provisions, the bill, one, expands the definition of a kinship caregiver by including a kinship parent and other individuals related or unrelated who have specified bonds or connections with the child or who have otherwise been identified by the child's parent. Two, requires the placement of a child with a kinship caregiver if a kinship caregiver is located subsequent to the child's placement in a foster care setting. And three, specifies if a kinship caregiver cannot be located, considerations that must be taken into account when placing a child in out-of-home care. There is an amendment in your packet. That's Amendment 303627. And that is a technical amendment. It alters the definition of relative in the Courts and Judicial Proceedings article to be a kinship caregiver as defined in the bill.
Yeah, I'd like to move the amendment. All right, it's been seconded. Now the bill's before you as amended. Motions were favorable. It's been seconded. Is everyone okay being reported in the affirmative? All right, Senate Bill 708 with amendment passes unanimously. We're going to stick with you with one more bill, Senate Bill 849.
Senate Bill 849 alters the definition of local government under the Local Government Tort Claims Act to include the Hagerstown Multi-Use Sports and Events Facility Incorporated in Washington County. There are no amendments.
Yeah, you all know the story behind this one. All right, Senate, all right, motions were favorable and seconded. It is everyone okay being recorded in the affirmative? All right, Senate 849. Senate Bill 849 passes unanimously. Senate Bill 890, that's Josh.
Senate Bill 890 alters the circumstances under which an individual who is erroneously convicted, sentenced, and confined may receive compensation, alters the benefits available to those individuals, requires the state to notify the individual in writing and provide specified information when it intends to introduce evidence to reduce or prevent an award of compensation, and repeals obsolete provisions. There is an amendment in your packet suggested by the Attorney General. It is number 773-026/1. The amendment would expand eligibility for compensation to include individuals who are erroneously convicted of conspiracy to commit a felony. Current law only includes individuals who commit a felony. Under Maryland law, a conspiracy to commit a felony is itself a misdemeanor. So this is a slight expansion of individuals eligible for compensation. And the amendment would also give those individuals who are newly eligible 2 years from the effective date to apply for compensation.
I spoke with the Attorney General's office of this. I think if this went into effect today, and I don't, for the record, I'm just saying that this would literally apply to 2 people in real life. So at the moment, which I'm glad, that's a good thing because that means, all right, the amendment's been moved. It's been seconded. Everyone okay adopting the amendment? All right, now the bill is before you as amended. Further discussion? Motions for favorable. It's been seconded. Is everyone okay being reported in the affirmative? Senate Bill 890 with amendment passes unanimously. We're now going to go on to Senator James, Senate Bill 107.
Senate Bill 107 establishes that a person has a lien on a motor vehicle if the person tows or removes the vehicle from a privately owned parking lot under specified provisions. And the lien would be for any charges incurred for towing, recovery, storage, or notice provided. A lien created pursuant to the bill must be extinguished if the motor vehicle is reclaimed and the charges giving rise to the lien are paid by the owner, lessee, or operator of the vehicle, the insurer, a secured party, or an authorized agent of the owner. There are two amendments in your packet. The first one, both from the sponsor, the first one is 713-528/1. With this amendment, any lien created by the provisions of the bill would be subordinate to any lien which is created before the creation of that lien. The second amendment in your packet is number 383-924/1, and this would remove from the bill a provision making it retroactive. So it would not apply to any towing which had occurred before the effective date of the bill.
All right, there's been a motion for the amendment. It's been seconded. Now is there okay with that? All right, now the bill, hold on.
Sorry,
All right, we'll slow down. We'll slow down.
like. They're two different.
No. We'll slow down. Now everyone's caught up. Just let's reread the amendment and go ahead.
So 713-528/1 would make any lien created by the provisions of this bill subordinate to any lien created prior to that lien.
All right, everyone's okay adopting that amendment. All right. Are there additional amendments for consideration?
The other amendment is number 383-924/1. This would strike a provision in the bill which makes the bill retroactive. So it would no longer apply to any towing which occurred prior to the effective date of the bill.
I'd like to move the amendment. All right, it's been seconded. Is that okay to adopt the amendment? All right, the two amendments. Yep. Senator Sidnor.
Quick question for council because I had a conversation with, I think, some of the proponents for the legislation, and they had talked about, I guess, the titling of the bill, calling the statutory lien versus a possessory lien. Is it?
It's a possessory lien by operation, but because we're putting in statute,
That's why they call them the statutory
you have to
lien?
call it a statutory
Very good,
lien.
thank you.
Yeah, that's the way it works. It's a statutory possessory lien. Maybe that's,
Further discussion? All right, motions for favorable with amendments.
Second.
Second, is everyone okay being recorded in the affirmative?
Yes.
All right, Senate Bill 107 with amendments passes unanimously.
what else?
All right, Senate Bill 1039.
Senate Bill 1039 authorizes the Circuit Administrative Judge of the Sixth Judicial Circuit to establish a truancy reduction pilot program in the juvenile court in Frederick County.
There are no amendments. With the senator from Frederick want to speak on it? If not, we can move on it.
Move the bill.
All right. It's been a motion for favorable. It's been seconded. Is everyone okay being recorded in affirmative? All right, Senate Bill 1039 passes unanimously. Senate Bill 894.
Yeah, it was sent over. Senate Bill 894 repeals the prohibition on an ordinance of Baltimore City or an act of any municipal officer from conflicting, impeding, obstructing, hindering, or interfering with the powers of the Baltimore City Police Commissioner. The bill takes effect June 1st, 2024. There is one amendment in your voting packet. That is.
I don't have it either. We're just gonna pause for a second while we get a printout of the amendment. All right, while we're getting that amendment, let's do this. Shamari, we'll come back to you. Senate Bill 46.
Establishes that a contract for the sale of a condominium unit is unenforceable if the contract does not contain specified notices related to the presence of asbestos. The committee has previously adopted amendments 233, 921/1. So in order to adopt the new amendment, the committee would have to strike the adopted amendment.
Thank you, Mr. Chairman. Right. Yep, okay. So, yep, I make a motion to reconsider the vote by which the amendment that's currently on the bill was passed. All right, two-step process. I motion that we reconsider the vote by which the bill passed the committee.
Second, is that okay? All right. Second motion.
And now that it's back before us, I make a motion to reconsider the vote by which the original amendment was adopted onto the bill.
Is that okay?
Yep. And so the second amendment in your packet is Amendment 123-523-1. And what that amendment does is it strikes a provision in the bill requiring that a contract for the resale of a condominium by a unit owner contain a statement as to whether the Council of Unit Owners has actual knowledge of asbestos on the site and whether abatement has been performed. And it instead requires that a seller include a statement as to whether the Council of Unit Owners has knowledge of any violation of the health or building codes with respect to the individual unit being sold, the limited common elements assigned to the unit, or any other portion of the condominium, including any violation of the health or building codes related to asbestos.
Sure. So what the bill does now that it's before you is that the bill requires disclosure of asbestos in condominium in the actual unit itself. Just as if you were selling a home or buying a home, such a disclosure would be required for a single family home. The question was about common areas because it's hard to work out common areas without accidentally immunizing the Council of Unit Owners or accidentally creating liability for the unit owners that they should not have. And so this was consensus language worked out between the representatives of the people who lobby on behalf of the Council of Unit Owners, as well as the Consumer Protection Division of the Office of Attorney General. So the amendment is a consensus amendment.
All right. Vice Chair has moved the amendment. It's been seconded. Is everyone okay? All right, now the bill's before you as amended. Further discussion? Motions for a favorable? It's been seconded. Is everyone okay being recorded in the affirmative? All right. Senate Bill 46 with amendments passes unanimously. All right, we are now back to Senate Bill 894.
So now you should have a copy of the amendment from the Baltimore City Senate delegation. The amendment provides that provides new uncodified language providing for a contingency. So the Act's provisions would take effect contingent on the passage of an amendment to the Charter of Baltimore City that provides for the appointment terms and terms of office and the powers and duties of the Baltimore City Police Commissioner and the powers and duties of the Baltimore City Police Department and its ratification by the voters of Baltimore City at the 2024 general election. However, if an amendment to the city charter that provides for the appointment, terms of office, and powers and duties of the Baltimore City Police Commissioner and the powers and duties of the Baltimore City Police Department is ratified at the 2024 general election, or excuse me, then if it is ratified, then it will take effect January 1st, 2025. If it is not ratified at the 2024 general election, these provisions will with no further action required by the General Assembly, shall be null and void. So it's entirely contingent on,
Yeah, right. I'd like to move the amendments. Seconded. All right, now the bill, everyone's okay. Now the bill's before you as amended. Senator Carter, you want anything to say? Or we want to move the bill? All right. Move. All right, actually, it's favorable. There's been a motion for favorable amendment. It's been seconded. There's a question. Senator Folden.
Like put that in what's being cut out in plain language.
sure. So if the voters
No,
approve.
not that.
Oh,
part. I'm
sorry.
just talking about the part that's cut out of the bill that says that no ordinance of the city or act of municipal officer other than the act of the mayor pursuant to Article 9 or Article 4 of this charter shall conflict, impede, obstruct, hinder, or interfere with the powers of the police commissioner.
Right. So that's part of the Baltimore City charter.
So if we take this out, does it allow the mayor of Baltimore to interfere or not? And that's what I'm trying to figure out here. Does it allow them to give an order to a police commissioner that may be contrary to
Right, so
law?
my reading of the current city charter provision is that it exists currently a prohibition where if something were to be construed as
Unlawful.
interfering, it would be against the city charter. So this would be removing that. And I'll defer to Senator Carter as far as the bill itself.
100% right. And I think that as we talked about the hearing, I'm trying to pull up the testimony, but this was necessary to ensure that the legislative control was transferred along with all of the other.
Essentially, what advocates have said who have presented to the committee is that this is and I won't try and even paraphrase the testimony, but that it is necessary after the General Assembly transferred state control of BPD to the city, that this was a necessary step for them, according to the city.
According to the city, but what is it according to law?
Well, I'm not gonna give an opinion on it. It's my understanding is that the city has said that they need this. So what I can tell you is what the city charter says and what the bill does.
So when you read the city charter, does it make you believe this is necessary to transfer this or to cut this part out?
That is the reading of it. That's why we had the bill. So I guess that I'm not saying much because I'm not sure that I understand what your question is. Maybe if I got better.
So Jamie, I just want to be clear. So it just says that no ordinance of the city or act of any municipal officer other than an act of the mayor pursuant shall conflict, impede, obstruct, hinder, or interfere with the powers of the police commissioner. When I read that, maybe I'm just being overly simple here, but when I read that, I see it that the mayor could literally give the police commissioner an order that may be contrary to his sworn oath.
I would need to, have.
You understand why
information
I'm
from the
looking
city.
at it and saying that,
Sure.
right?
No,
Because
I absolutely. But, I think that, the city is probably in their, law department is probably the best to, we would need to consult them for their interpretation.
but we're passing it from a state. We're passing it from the state, though. We've got to know what we're passing to them. And if I look at this and it says that other than an act of the mayor, that basically, other than the act of the mayor, that and again, maybe I'm oversimplifying this, but that it appears that he could give an order that would conflict, impede, obstruct, hinder, or interfere with the powers of the police commissioner. Which, if I'm going back to when the state took it over, would have been precisely why that was in there, so that they could not interfere with that.
It may be helpful to say, or to look at it in its whole, the whole text of it.
Yep.
And that being that the mayor and city council of Baltimore have full power and authority, going to page 1, to exercise all of the powers heretofore or hereafter granted to it by the Constitution of Maryland, or any public general or public local laws of the state of Maryland. And in particular, without limitation. So I wanted to sort of.
And I want to be clear on that. I understand and I appreciate what you're saying. This brings me back to the concern that I had, because we had a state's attorney in Baltimore who decided that nuisance crimes were no longer going to be enforced. Were no longer going to be adjudicated or given charge. They were going to be, if they were charged by the police, they were being dismissed. So that is contrary to that person's role at that time, to the Constitution of Maryland, to just say arbitrarily, we're not allowing you to, we don't enforce those. It happened. I'm just making you aware. So here again, we have something coming forward that says, oh, the county council and the mayor shall have full authority and power to exercise all the powers hereto and hereafter granted to it by the Constitution of Maryland. But when I go down further, and this is what I'm asking for the clarity on, because I'm not clear on it. When I read it, it makes me believe that there is an opportunity that the mayor by could ask the commissioner to, not that any mayor would, but any mayor could go and ask them to do something contrary to their obligation to the Constitution of Maryland and enforcing the law.
I think that lead-in language probably does cover the situation that you're talking about, Senator, because it limits the power of the mayor and city council to those that are granted to them by the Constitution or by any public general or public local laws. The lead-in language doesn't say that they could go in excess of the Constitution.
I know that. I know that. And the language that the former state's attorney swore to also said the same thing, but it was violated by her not doing the job. That's what I'm getting at, is that you're asking people, there was an ask of people to do something that was contrary to their responsibility.
Because I'm confused about your interpretation. Because this language, as I read it, is limited to the mayor and laws passed laws of the city of Baltimore, municipal laws. What a state's attorney is not a legislator in Baltimore. They would not be able to make a law. Like they don't direct the actions of the police. So I don't understand how a state's attorney has anything to do with this. Help me understand.
But that's fair. I understand.
According to the city testimony, the Attorney General wrote an opinion, which I just asked them to send me, which said that to do this language, it would make it cleaner.
All right, so have we adopted the amendments? Sandy?
All right, yeah, I think so. No, you haven't.
All right, the motion's to adopt the amendments for Senate Bill 894. This is amendment 21372/1. It's been seconded. All right, so, all right, now the bill's before you as amended. Motions for a favorable. It's been seconded. All right, do we need a roll call? Is everyone okay being recorded in the affirmative? All right, everyone, Senator McKay and Senator Fulton are not here, so. All right,
That 7-5, that you understand why this process is taking.
no, this is,
3 years we worked on this. And I remember one time I was on the Zoom call back during the pandemic.
you put a kiss west on.
State senator from Baltimore City for having the temerity to be interested in in giving the city the power to control its own police commissioner. Why are you interfering with us? I said, because I think it's the right thing to do. I still think it's the right thing to do.
So this is going down, when this passes, it's from 1850 all the way through to now, 2024 is finally when Baltimore City will have full control over its police department.
Right.
All the way back to 1850, which is incredible. All right. Let's move on to Senate Bill 665.
Senate Bill 665 reduces from 80% to 66 2/3% the threshold of unit owners listed on the current roster of a condominium needed to consent to an amendment of the condominium's declaration once all units have been sold by a developer. However, the existing threshold of 80% is still applicable if any of the units of the condominia are owned by the developer.
All right. There's been a motion for a favorable. It's been seconded. Is everyone okay being recorded in the affirmative? Okay. Senate Bill
665.
665. Senator Fulton, you're okay with 665? Give him a second. Give me a second. Senate Bill 665 passes unanimously. All right. Senate Bill 687.
Senate Bill 687 repeals provisions relating to bail bonds in the Seventh Judicial Circuit. Specifically, the bill repeals Section 5203B of the Criminal Procedure Article governing bail bondsmen's and related fees in the Seventh Judicial Circuit, and repeals 5209B of the Criminal Procedure Article exempting the Seventh Judicial Circuit from certain requirements for property bonds persons. The Seventh Judicial Circuit is comprised of Calvert, Charles, Prince George's, and St. Mary's counties. In speaking with the representatives from the judiciary, we were advised that St. Mary's County does not participate in the bail bonds process covered by the bill. And we have received delegation letters for the senators for let's see, Calvert and Prince George's. We did not, as far as I know, receive anything from Charles.
I think we were. I think I know that. I think we're good to go with Charles. So I'd like to move the bill. All right. Second, is everyone okay being recorded in the affirmative? Okay. I know. Give me a second. You want to do your, which one?
Yes, that's withdrawn.
Yeah.
Do you just want to just withdraw it real quick?
Senate Bill, what, 410?
Okay.
410 is the motions for unfavorable withdrawn. Is everyone okay with? All right, seconded. Everyone's okay with that. All right, Senator West. This is let's do it's Shamari, Senate Bill 793. 793.
Senate Bill 793 clarifies the responsibilities of the state and local governments and establishes related procedures for claims filed in state court under the Maryland Tort Claims Act against the sheriff or deputy sheriff engaged in a detention center function or law enforcement function. The bill also expresses the intent of the General Assembly regarding various provisions of the bill and cooperation and collaboration between specified stakeholders regarding allocation of responsibility for these tort claims. There are no amendments.
Gee, I have an amendment here in my file. But it's tiny. Inserts a bracket, inserts two brackets, and inserts a comma. Huh? All right, can I just read it? On page 3 in line 4, after act, insert a bracket. And in line 5, after section, insert a bracket. And on page 4 in line 11, after considered, insert a comma. I think the states that they gave this to me.
All right,
came from Mako.
Can you give the amendment to council? He'll
I'll be
review it,
happy
and then we'll come back to this.
Yeah.
All right.
Go to that non-controversial 100.
Josh, let's go to Senate Bill 464.
Senate Bill 464 authorizes the State Highway Administration to decrease the maximum speed limit on a highway under its jurisdiction without an engineering and traffic investigation if the administration is only decreasing the maximum speed limit by 5 miles per hour. There is an amendment in your packet. It's number 483023/1. This is just a technical amendment that conforms the bill to House Bill 278, which is a very similar but not identical bill, which has already passed the House.
I'm just going to move the amendment, then we can discuss the bill as amended. All right, is that okay? All right, now the bill's before you as amended. Further discussion.
Why are we authorizing SHA to reduce a speed limit by 5 miles per hour without a study? That's my question. I mean, the roadways are designed through traffic and engineering to handle speeds, and that's how they're determined, by the curves of the road, by the super elevation and the like, the slope. I don't know why we're putting a bill in that says, well, they can just move it down 5 miles per hour unless it's something that they're wanting to pressure in from the local level for them to do that without a study. I don't know why we wouldn't stick to the law, which is required to be a study.
Another thing too, just exactly which state highways does this apply to? Just want to make sure clarification.
So it's highways under the jurisdiction of the State Highway Administration in urban areas, which is a defined term in the bill, which appears on, the bottom of page 1 into page 2. So you can see it's constructed with a curb and gutter and an enclosed type of storm drainage system located in an urban area and on which is located a public facility that creates appreciable pedestrian traffic along the highway from adjacent areas located within urban boundaries as defined by the U.S. Census Bureau or located within the boundaries of a municipal corporation.
So I want to be clear, this is an attempt. They keep saying highway and most people think of roadway speeds that are 55. It's a roadway that is, they're wanting to be able to take it down from, 25 to 20 miles per hour. This is something that was attempted before and then they placed these speed cameras in place. The Maryland traffic law, the Maryland vehicle law, if you look at it, they even cite it under 21-801.1 is in there. And those guidelines are there for a reason. That is what people are trained on when they take driver's education. They know if it's not posted, that is the speed limit. They know that if they're in a residential area with the speed limits are what they are, even if it's not posted. Now we're taking the opportunity to move these speed limits down by 5 miles per hour just because we feel like it.
So I'll read you some of the testimony this is from Advocates for Highway and Auto Safety. And the committee can decide whether you think this is persuasive or not. But so speed is a major contributor to crashes in Maryland. In 2021, of the 561 traffic fatalities in the state, 30%, 168 were speeding related. Moreover, urban areas in Maryland are particularly at risk, as 91% of the state's traffic fatalities occurred in urban areas. In addition to being tragic, the unnecessary deaths resulting from speeding are costly. Maryland incurred $5.9 billion in economic harm, which is the equivalent of $956 per resident due to motor vehicle crashes, according to a 2019 analysis. Then it goes on, vulnerable road users are particularly impacted by small changes in speed. The average risk of death for a pedestrian is 10% at an impact speed of 23 miles per hour, 25% at 32 miles per hour, and 50% at 42 miles per hour. Lowering speed limits will save lives, and so it goes on.
What was the last part? They were talking about speed and deaths.
So vulnerable road users are particularly impacted by small changes in speed. The average risk of death.
So you're talking about pedestrian.
Yeah, for a pedestrian is 10% at an impact speed of 23 miles per hour, 25% at 32 miles per hour, and 50% at 42 miles per hour.
So
and then it goes on.
Again, this goes against everything that we've got in law. If they want to lower them, do the traffic study. It's already in law. Why are we making it that they can just do it without calls? This is a common theme. If you've got a concern, have it be consistent. Most studies are done where there's a high collision frequency area. And then they go out there and they assess it, because the reality is people drive at speeds that they're comfortable with. They're not sitting there always looking at, okay, this is the speed limit. Let me just stick to that. If the roadways lanes are wider, they're going to go faster. If you make changes to the roadway lane widths, they'll go slower because people inherently want to stay inside the lanes. I just don't understand why we're giving somebody why this bill is necessary when we already have a provision in place to do a study and they can change it. Let them do it.
From the committee. Oh, it's a high-speed discussion.
It looks like it wants. Is this
someone laughed at my joke? Right?
Do we want a local bill here so that they can do it? It's somebody in a urban area, and I respect that they want this, but we're wanting to make it a statewide bill.
We're going to hold it till the next voting session.
Thank you. You are welcome.
those, I'll just read it again. Senate Bill 793 clarifies the responsibilities of the state and local governments and establishes related procedures for claims filed in state court under the Maryland Tort Claims Act against the sheriff or deputy sheriff engaged in a detention center function or law enforcement function. The bill also expresses the intent of the General Assembly regarding various provisions of the bill in cooperation and collaboration between specified stakeholders regarding allocation of responsibility for these tort claims. And so there is an amendment. And so what the amendment does, page 4 of the bill, it just corrects a typo. A tort claim shall be considered defended, settled, and paid in the same manner as any other claim filed against the county. It should read, a tort claim shall be considered, comma, defended, comma, settled, and paid in the same manner as any other claim filed against the county. And so page 3 of the bill, line 4, the amendments strikes the text for personnel covered by this section. And so it should read, with the amendment, a county or Baltimore City may obtain insurance to provide the coverage and defense necessary under the Maryland Tort Claims Act.
Yes, thank you, Mr. Chair. This is a complicated bill. It solves the problem of local law enforcement work that's performed by county sheriffs and deputy sheriffs. Generally speaking, the sheriffs and the deputy sheriffs guard the courthouse. That's what they do. But if they also do local law enforcement work, there's a problem with tort claims against them for the time that they're spending on local law enforcement work. So let me just read a sentence of my testimony. The bill establishes a circular route for judgments entered in lawsuits arising out of local law enforcement work performed by county sheriffs and deputy sheriffs to ultimately be paid by the local government's insurance trust. Right now, there are judgments being entered against the local governments or the state. This ends up, if they're sued for local law enforcement work, the local government's insurance trust is going to pay those lawsuits. This was a MACO bill to solve a problem. So I move favorable on the bill. Well, I guess the amendment, this minor amendment plus the bill.
Adopt the amendment, and then we'll have further discussion. If it's okay to adopt the amendment. All right, everyone's good. All right, Senator James.
Senator West, in my county, so the sheriff is, the law enforcement, right? We have municipal police, but he does all the local law enforcement. Chief law enforcement officer, right? So how does this affect my county?
Anytime he's sued and a judgment's entered, the judgment will be paid by the local government's insurance trust.
What's happening right now, or do you know, in my county?
I don't know what's happening in Hartford County.
You don't?
I don't know how it works.
So,
but in many counties in the state, the judgment is currently is entered against the local county. And so that's not what anybody intended, but because of quirk of the law, that's what's happening. So
when you say local, I'm just trying to understand it.
Yeah.
There is a local, what are you creating, a trust fund of some kind?
there is a trust. It's called the Local Government's Insurance Trust, which all the local governments, they buy insurance. And it should cover, this stuff.
Investment pool.
But right now it's not. So this bill will provide that those judgments against your local sheriffs in Hartford County will be paid, those judgments will be paid by this local government's insurance trust and not by Hartford County.
So it shifts it over there, and then all the counties pool their resources into that trust. Is that
Exactly,
correct?
precisely.
Okay, thank you.
Yeah.
Yeah, so like some counties, like bigger counties will do their own, like Baltimore City self-insures, and then smaller counties do, like they pull together to insure themselves. But yeah,
You might sell for all I know.
I think Baltimore City is the only one that does that. Maybe, I don't know. But then does this say that because they do both like state work and local work, that for it?
The state is already covered, the state things. So this
Thank
covers the local work.
Got it.
you.
All right. Motions for favorable with amendments.
On 464 still,
Yes,
and.
it's been seconded. All right, is everyone okay being recorded in the affirmative?
And everybody approved the amendment.
Everyone did approve the amendment. So Senate Bill 793 with amendments passes.
464?
No, this is Senate Bill 793.
Oh, you held 464. Okay,
Yeah,
all right,
yeah.
so
Passes favorably with unanimously with the amendments. We're gonna go to Senate Bill 17.
Of Washington. Senator Muse's floor amendment would add an uncodified provision requiring the State Department of Assessments and Taxation to report to the General Assembly on the potential impact of repealing certain provisions of law that apply to the Methodist Church and require property owned by any Methodist church to be held in trust for the United Methodist Church. So it would simply be a study and a report on any impact of repealing those existing provisions of law.
I believe as the floor leader, my instruction is to accept the amendment as a friendly amendment. That's my intention. Yeah.
All right, we'd attack back to Senate Bill 17. Yeah, no worries. Thank you. Jamie.
Senate Bill 17 establishes that each animal harmed in a violation of Title 10, Subtitle 6 of the Criminal Law Article, which pertains to crimes against animals, is a separately chargeable offense. The bill specifies that one, a conviction for a violation of the subtitle cannot merge with a conviction for any other crime based on the act establishing the violation. And two, a sentence imposed for a violation of the subtitle may be separate from and consecutive to or concurrent with a sentence for any other crime based on the act establishing a violation. There is one amendment in your voting packet. That is amendment number 803-920/1. The amendment changes language on page 1 of the bill or page 1 of the reprint. The new language would provide down at line 18, for the purposes of this subtitle, each animal harmed in a violation of this subtitle is a separate offense and shall be deemed an individual victim for purposes of the sentencing guidelines stacking rule.
Thank you, Mr. Chair. So the problem with current law is if a person is arrested for animal abuse because the person has a cage and say there are 20 dogs inside the cage and they all have welts all over them and they're all near starvation. So 20 badly abused animals, the person can only be charged with one offense and probably isn't going to go to jail at all. He'll probably get probation. So this enables the state's attorney in that county to charge them for 20 offenses. And the court would have the prerogative, if it chooses to do it, of imposing consecutive sentences for all 20 offenses.
Thank you. If I'm missing something, I apologize. Are you saying, would this be the case if it were not able to be discerned when the different incidents occurred? Or are you saying like if there's one act that caused all of those 20 different injuries?
Proposed statute, each animal harmed is a violation, is a separate offense. So you would have not one offense.
Oh, each animal?
Yes.
I got it. I thought you were saying like one animal, different injuries. Okay.
No. If you have 20 dogs, you could have 20 separate offenses, whereas right now, all you have is one offense.
What's the one? What's the one?
One offense for abusing animals.
Oh, okay, one,
Right.
okay.
So now we'll have one offense for each dog
For
that
each
is
dog,
abused.
okay, got it.
Did you?
What's the genesis of the amendment? Just you were saying it's like clarifying, or can you tell us what?
To be honest, the advocates came to me and said there's some internal dissension and they want to work on an amendment, and took them a couple of weeks. And then 2 weeks ago, they came and said, it's all done. The amendment, we have a consensus amendment. Everybody agrees to it. And this is the consensus amendment. Senator Sidner asked me to explain how it came up. We're both members of the Sentencing Commission. And at the Sentencing Commission one night, the state's attorney, who was on the commission from Calvert County, said he ran into this problem. That there in Calvert County, there was a pen and there were like 20 dogs in the pen and each has been foully abused, but all he could do was charge one offense. So that's why that was the genesis of this bill.
All right, you want to move your amendment?
Yes, I move the amendment.
Second. Is everyone okay adopting the amendment? All right, now the bill's before you guys. Amend. Further discussion.
I move the bill.
All right, there's been a motion for a favorable. It's been seconded. Senate Bill 17 with the amendment.
Animal bill.
Do you like that? You're good? Only if you're going 5 miles lower without a traffic study. If you run over a Fido, it's a felony. All right. All right, Senate Bill 17 with amendments passes unanimously. Let's go on to, this should be when it's due 1101. Senate Bill 1101.
Yep. Senate Bill 1101 is drafted, establishes the police officers' educational benefit scholarship, 1 and 2, subject to availability of funding. The first scholarship provides officers with a minimum of 5 years of service or the dependent children of such officers, and under scholarship 2, provide scholarships to officers with a minimum of 10 years of service or their dependent children. Additionally, the bill expands the duties and requirements for the Maryland Police Training and Standards Commission to require law enforcement agencies to develop and implement policies for the recruitment at historically Black colleges and universities in the state by April 1st, 2024, and each April 1st thereafter. Each law enforcement agency must report to the Governor's Office of Crime Prevention and Policy on the education level of all police officers employed by the agency. GOCAP must compile the reported information and submit it, an annual summary to the Governor and General Assembly. The bill takes effect July 1st, 2024. There is one amendment in your voting packet that is Amendment 503723/1. That is for Senate Bill 1101, and that is Amendment 503723/1. The amendment does a couple of things. It strikes provisions of the bill as drafted. And instead, if the committee turns to page 11 of the reprint, the bill instead alters an existing scholarship program under the, and I can give you the name of it.
The Maryland Police Officers and Probation Agents Special Scholarship.
There we
Program.
go.
All right, so it's essentially there's $8 million in this program that are unused. Senator Bailey actually found this. And so what this amendment does is it strips out the program before and it slides this and adds in eligibility for an associate's degree. So a 2-year degree that folks can tap into this fund, which is already there. So the fiscal note, there will be no fiscal note because the money's already there. And so it just opens up the aperture of eligibility for police officers to go ahead and get their associate's degree. All right. Sorry, amendments been moved and seconded, but Senator Sidner has a question.
Quick question, because I should know this, but I'm not. The proper term for it says a probation agent. Is it a probation agent or is it a probation officer?
Yes.
It's an office. I'm asking because I know correctional folk don't like being called guards and they like being called correctional officers.
Sure. I'm would have to take a look for you, Senator. That provision is existing law. So that was, I can absolutely take a look for you and get back to you. But yeah.
Oh, thank you.
All right. So the amendment's been moved and seconded. So everyone okay adopting now the bills before you as amended? Motions for favorable has been seconded. Is everyone okay being recorded in the affirmative? All right. Senate. Sure. Senator Fulton wants to be added as sponsor. Senator McKay, Senator West. And so this broader bill of 1101 I hope will be some baseline product for Senator West's retention and recruitment work group that maybe they can build upon this idea and build it out. Senator James wants to be added on. Thanks. All right. Let's call it. We got 3 minutes. When we come back, we've got a retail theft bill that we're going to work on. We're not coming back tonight, but tomorrow. Oh yeah. Retail theft bill. We've got some expungement bills from Senator Carter that we're going to work on, and then we're going to make another run at this noise abatement thing. Maybe I got some more information for you all to convince you. All right. See you all on the floor. We're not coming back tonight. Tomorrow, what time is floor?
I won't know that until you guys get off.
All right, we're not doing anything before floor. So no.